What minimum language should be written to a settlement agreement with a debt buyer? Well, this is part 2 of the Confession of Judgment video. I'm going to show you language that should be included in a settlement agreement with a debt buyer's attorney. And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flesses. Settlement agreements are usually drafted by the debt buyer's attorney, and that's normal. But there should be specific language included in that agreement to protect you. Remember, from the Confession of a Judgment video, I told you that you should never sign a confession of judgment or admit to the amount that you're being sued for. If you missed that video, you should watch that one. The language in the settlement agreement must state the following basic terms to protect you. Are you ready? Make sure that the case number and name of the court for the case that you're settling in is written on the settlement agreement. That both parties have mutually agreed to settle the case. That your payment, for example, of $300 is made in exchange for the release of any and all claims that the debt buyer has against you for the debt. That the payment of $300 or whatever amount it is accepted by the debt buyer as a full and complete settlement. That the debt buyer acknowledges receipt of the $300. That the debt buyer warrants and represents that they are the exclusive owner of the debt and they've not transferred their interest to anyone. That the debt buyer hereby releases you forever from any and all claims for the debt. That in the event that you are ever sued again on this debt, which could happen, that the debt buyer will defend you and forever hold you harmless. But if the attorney won't include that, the satisfaction of judgment it's going to serve as evidence that you paid the debt. That the settlement amount will be paid simultaneously with the signing of the settlement agreement. That the debt buyer will prepare and file a satisfaction of judgment with the court and provide you with a copy of the filed satisfaction document within 14 days or whatever days that you figure out of the date of this agreement. Date the agreement. Very important. People forget to do that. Both parties then sign the agreement. The attorney should indicate below their signature that they are the attorney for the debt buyer. If you entered into a settlement agreement, post your comments below and let me know your experience and if it was successful. You know that I reply to comments. I'm attorney Robert Flesses. Thanks for watching. Please subscribe and I'll see you in the next video.